Ready for dictation, start. This first miscellaneous appeal is directed against an order being number 2 dated 17th April 2017 passed by the learned civil judge Bracted Senior Division First Court at Barsat in title suit number 281 of 2017 at the instance of the plaintiff appellant para. By the impugned order, the plaintiff's prayer for ad interim injunction was refused by the learned trial judge. Notice was directed to be served upon the defendant numbers 2 to 7, asking them to show cause as to why temporary injunction as prayed for by the plaintiff shall be granted against them para. Let us now consider the legality of the said judgment in the facts of the present case. It is stated by the plaintiff that the plaintiff and the defendant numbers 1 to 3 were partners of an unregistered partnership firm. They purchased the suit property by several registered deeds of Kabola, while all of them were partners of the said partnership firm. Such purchases were made in the name of the partnership firm represented by the plaintiff and the defendant numbers 1 to 3 as its partners. It is alleged in the plaint that some of the co-sharers have executed a deed of partition without joining of the plaintiff and thereby effected partition of the suit property illegally. Since the defendant numbers 4 to 7 are claiming ownership over the suit property on the strength of transfer of the suit property from some of the co-sharers, they are also implicated as defendants in the instant suit. Since the plaintiff was facing difficulty in enjoying the suit property jointly with his co-sharers, he made a request orally to the defendant numbers 1 to 3 for amicably partition of the suit property. Such prayer of the plaintiff having been turned down by those defendants, the instant suit for partition was filed by the plaintiff para. After filing the suit, the plaintiff filed an application for temporary injunction for restraining the defendants from disturbing his possession in the suit property and also for restraining the defendants from changing the nature and character thereof till the disposal of the suit. Relief by way of ad interim injunction was also sought for by the plaintiff in the said application para. The learned trial judge, after perusing the materials on record, came to the conclusion that the plaintiff has failed to satisfy the court about the existence of the prima facie case in the suit. Such conclusion was drawn by the learned trial judge by considering the deed of partition being annexure Bracted E, whereby the suit property was partitioned amicably amongst co-sharers, and the reason for excluding the plaintiff and the defendant number 1 in the process of partition was not found to be unjustified, as they had relinquished their share in the partnership firms.